Well, good morning, all. Yeah, we adjourned yesterday at about 12, and Advocate Maleka was still cross-examining. If I may just remind the witness, ma'am, you're still under oath?
Yes, Chair.
Yes. Thank you. We may then proceed.
Thank you, Chair. Chair, we would like to finish our cross-examination this morning if we can. Yes. And if I don't look into your direction fully, it is not out of disrespect. The flashlight has been set right in our direction. Would you like us to move? Not at all, just in case, so that the optics should not send any message whatsoever. Ms. Ngoye, good morning.
Good morning, Mr. Maleka.
Can we deal with the new topic, and that is the findings of the Auditor General relating to a number of irregularities that she found upon her audit of Process Financial Affairs. Chair, the Auditor General's report that I'd like to deal with is in volume 16.1. 16.1. Yes. I believe that the correct description on the spine of the file is 16.1. Yes, Chair. The report begins at page 381. If the members of the tribunal do not have it ready, I will simply give references and read aspects of it that may be critical for our own purposes. Chair, as I said, the report begins at page 381. Are you there, Ms. Ngoye?
I don't have it yet, Chair. They're still looking for it.
Right. There might be a spare copy from our side that we can place before you.
Sorry, Chair, we're just going to look for our copy unless we've got a spare one. Okay, thank you, Council.
Thanks. I do have it, Chair.
Can I ask you to turn to page 381?
I'm there.
And I take it that you are familiar with this report. When I say familiar, I'm not suggesting that you recall each and every part of it, but simply the fact that it is from the Auditor General and it is dated 31 March 2017.
Yes, I can see that,
You
Chair.
can confirm the date on page 381. And so our understanding is that it was a reflection of the audit process, outcome, and findings by the Auditor General before Judge Makhubele joined PRASA as its chair of the interim board, correct?
Yes, it would be, Chair.
One of the things that the Auditor General investigated, audited and reported upon was process engagement of workmen's attorneys to conduct some forensic and legal investigation on behalf of the board. And I recall at the time the chair of the board was Mr. Molefe.
That's correct, Chair.
And the findings that the Auditor General made in that regard begin at page 450. You will see at 450, the heading is Audit Findings. Are you there?
I'm getting there, Chair. I'm there.
Okay. And I'm not going to talk about the legal framework the Auditor General had regard to in support of his findings. All I wish to ask you is to turn to page 450, and you will see that she identified, or I think it was Mr. Makhubele at the time, isn't it? Yes. Mr. Makhubele identified an expenditure in the order of 3,941 rand and 73 cents as an amount that was paid to workmen's attorneys for its services, correct? Right at the top of page 450. You will see that this is heading Service Provider.
450.
451.
Okay. Yes. I see it, Chair.
Yes. And there's a finding she makes in that regard immediately below the table. The Auditor General of South Africa was unable to determine whether the procurement process followed was fair, equitable, transparent, competitive, and cost-effective, and compliant with the prevailing SCM prescripts due to non-submission of the required information. This is non-compliance with the provisions of the PFMA and the Public Audit Act. Do you see that?
I do, Chair.
And then she goes on to say, furthermore, the Auditor General of South Africa was not provided with a deviation approved by the board in this regard. See that?
Yes, I do.
And then she concludes that there is a risk of irregular expenditure. Do you see that?
Yes. Yes, Chair.
And then she makes a recommendation flowing from that finding. She says management should ensure that all SCM record keeping is properly maintained. All outstanding information is provided to the Auditor General immediately for review. And then there is a response by management, and the response is put in that box rectangularly. And I've read it, but you can read it. To sum up, Chair, quite clearly, management accepted the findings by the Auditor General. In other words, there was no dispute about the correctness of that finding. Do you see that?
Yes, I do, Chair.
And she concludes in the second bullet point about your response as management. According to Treasury regulations, there are a number of procurement procedures that can be applied when emergency or urgent procurement is imminent. The Board of Control agreed that this matter be dealt with in closed/negotiated/nominated procedures as threats were not known where they emanated from. You see that?
I do, Chair.
So in sum, the Auditor General repeats what we all know as lawyers, that the default rule of procurement is competitive procurement, and if circumstances arises where there is a need for deviation, amongst others based on emergency or urgency, then you have to apply Treasury Regulation 16, capital A, correct?
No, I don't agree with that, Chair.
What is your understanding?
My understanding is that if there is a deviation, Chair, if you want to deviate from your own policy and the law, you would apply to National Treasury for permission to deviate. And if they agree with you, they will grant you the deviation. If they don't, then they will advise you accordingly. So I don't understand that 16A, therefore, is the default position. Regulation 16A is the default position.
I'm sorry, maybe I did not make myself clear. I'm saying the default position is one of competitive procurement.
Okay. Yes. Yes, Chair.
But so far as the deviation is concerned, I don't want to start a debate between you and I. I will work with your own understanding. And you have confirmed that your understanding is you apply to National Treasury and it has to authorize the deviation.
That's correct, Chair.
Okay. Now, if you go to page 452, you will see that there are 4 columns from the top. The one that I am interested in is the last one. Let's start with the second last one. There is remedial action which the Auditor General stipulates. Do you see that?
Yes, I do, Chair.
And then the next heading that follows in the last column is what actions will be taken and by whom and the date. Do you see that?
Yes, I do, Chair.
So the date for remediation called for by the Auditor General is the first quarter of 2017. Do you see that?
Yes, I do, Chair.
Okay. Chair, I'm just going to ask you to note the conclusions by the Auditor General at the end of page 452. I'm not going to deal with them for the sake of progress, but I highlight them now because they would become important in the course of argument later on. On page 453, the Auditor General also note, if you're there, a
Yes,
deviation approved by the board has also not been provided for audit to substantiate not following the procurement process. Do you see that?
I do, Chair.
Yes. So that's another basis of the Auditor General's finding that there was an irregular expenditure, at least as far as Workspace is concerned, correct?
That's correct, Chair.
Yes. Now, I'd like to take you to 458. You will see that that's an audit finding of the Auditor General, but this time in respect of the use of panel of lawyers by PRASA beyond Worksman's. And again, at page 458, the Auditor General has regard to the legal framework in support of that finding. Chair, I'm not going to deal with it. We have seen it before. The key part of the finding she makes begin at page 459. Do you see that? And you'll see that under the table, she gives the figures for different financial years relating to the amounts which PRASA spent on the panel of lawyers it used in a manner that was irregular and resulted in irregular expenditure. Do you see that?
I do, Chair.
Yes. Chair, the left-hand first column reflects the number of years from 2011 up to 2017. Slightly dark, but one could see the figures. And thereafter, progressing to the right-hand column, you'll see the number of amounts expressed annually. And the total is at the bottom end of the table. And the sum total is 325.55 rand. Do you see that?
Yes, Chair.
And then the basis of the audit finding by the Auditor General is right below the table. The AXA, Auditor General of South Africa, was unable to determine whether the procurement process followed was fair, equitable, transparent, competitive, and cost-effective, and compliant with the prevailing SCM prescripts due to non-submission of the required information. This non-compliance with the provisions of the PFMA and the Public Audit Act. And then she goes on to make recommendations. They are reflected on page 460. I'm not going to deal with it. And she says, on management's comment on internal controls and deficiencies, again, we have seen that approach when the Auditor General dealt with worksmen. I merely wish to draw them to the attention of the panel, but you may comment if you want to do so. My interest lies in the actions that management undertook to correct and remedy the findings of irregular expenditure. You will see them right at the end of the of page 460. Again, management undertook to remedy the issues by first quarter of 2017. Do you see that?
Yes, Chair.
Yes. The point of these questions is that there was a need for PRASA to deal with the irregular expenditure identified by the Auditor General, flowing from the very portfolio that you headed, and that is legal risk and compliance, correct?
That's correct, Chair.
And what we know is that when the board that was appointed in 2017 on an interim basis came into office, amongst others, it dealt with that issue. Correct?
Yes, Chair.
Yes. And one of the things it did in dealing with that issue was to adopt a resolution at the special meeting of the board on the 1st of December 2017. Remember that?
Yes, I do, Chair.
I'm done with it. Yeah. Can you give me the resolution? This is volume.
This is 16 of 4.
Chair, the resolution is in volume 16 of 4. It begins at page 298.
Volume 16.
16 of 4.
Yeah, okay. Thanks. What time do you do? Okay.
You take me there. Chair, if you don't have it ready, I can read it. Thank you. Page 298. We have looked at this document before, and we know that the concern of Ms. Ngoye was the fact that it was not signed. I'm not going to deal with that issue. I think we've dealt with it. Ms. Ngoye, you'll see that the number of the resolution on the face of it is given immediately after the top box that records certification of it. Do you see that?
Yes, Chair.
This BOC, Board of Control Resolution number 2-1, 1217. That I see, or I read to suggest that is the second resolution of the Board of Control adopted on the 1st of December 2017. Would that be a fair meaning given to the numbers?
I understand that, Chair. Yeah.
And you will see that the first paragraph deals with the collation of investigation reports called for by the board from the Group Chief Executive Officer. Do you confirm that?
Yes, Chair.
Yes. And I assume that you would have no difficulty if at the end of the inquiry evidence, we suggest that the board requires the acting chief executive officer to provide it with investigative reports of the matters referred to in paragraph 1 of the resolution.
Yes, Chair.
And then in paragraph 2, on page 298, the resolution deals with submission of litigation matters. Do you see that?
Yes, I do, Chair.
And the resolution records as follows: the executive legal risk and compliance must hand over all litigation files relating to contract and/or contractors emanating from the investigation to the office of the company secretary. Do you see that?
Yes, I do, Chair.
And that will be a board requirement directed to your portfolio, correct?
Yes, Chair.
If you go to the next page, 299, the resolution continues as follows: the litigation file submitted should be accompanied by a progress report on the status of each of the matters before court. Do you see that?
Yes. Yes, Chair.
And then I have dealt with worksmen, so I'm not going to deal with it again, but you will see that what the board required there was a detailed statement of account. Do you see that?
Yes, I do.
And I assume that you'll accept at that point in time that this being a new board in office for a month and a half at best was entitled to ask for this information.
Yes, Chair.
And then for the status of legal panel, management should provide a report to the board on the status of the legal panel and provide reasons why the legal department still uses a legal panel that appears to have expired. Do you see that?
Yes, I do, Chair.
So that as a matter of fact, or let me rephrase, as a matter of inquiry, the board at that time took the view that the panel which was on the procurement list utilized by PRASA had expired, correct?
That's correct, Chair.
Yes. And that conclusion is also reinforced by the fact that the Auditor General had already made a finding of irregular expenditure in relation to that panel, correct?
That's correct.
So there was a need to deal with it, one way or the other.
Yes, Chair.
That board could not have folded its face and say, business as usual from 2011 should continue.
That's correct, Chair.
Yes. And the next bullet point, it says the legal panel is suspended with immediate effect. Do you see that?
I do, Chair.
Yes. The board was entitled to take that view or that decision in the light of the two things that we have now dealt with. The fact that that panel status had expired and the fact that there were irregular expenditures flowing from the continued use of that panel. Correct?
That's correct, Chair.
And I suppose that if you were the head of the board at that time, you'll take the same decision.
Suspend the legal panel.
Yes.
Yes, Chair.
And the last bullet point under paragraph 4, it says any legal services sought must be procured through the SCM processes and in consultation with the chairperson of the Board of Control on all matters relating to investigations only. Do you see that?
Yes, I do, Chair.
And I assume that the board would be entitled to say, let's apply the rules that the Auditor General has identified. Procurement must be done through SCM policies. Correct?
That's right, Chair.
Yes. The last part of the resolution deals with the Section 34 PRECA reports. You remember at some point in one of the documentation we looked at, you also referred to this section
Yes.
of PRECA.
Yes, Chair.
Which requires any person in public office with the knowledge of corrupt activities to report those activities to the South African Police Service. Remember that?
Yes, I'm aware, Chair.
And what this board does in that regard says the following: management should provide the board with a signed resolution in terms of Section 34 of the Prevention and Combating of Corrupt Activities Act, and the rationale to pass such resolution, conferring to the GELRC the authority to transact in terms of Section 34. What is GELRC?
I guess it refers to the Group Executive Legal Risk and Compliance. We've established that.
Again, that resolution is directed to your portfolio.
Yes, Chair.
Yes. And I assume that you, if you had knowledge of corrupt activities, as from December 2017, you will be required to consider complying with this resolution in terms of a Section 34 PRECA report, correct?
I don't understand, Chair. This is not what this resolution is suggesting. Perhaps I can get clarity.
Let me ask you, what is your understanding of this resolution?
Management should provide the board with a signed resolution in terms of Section 34 of the Prevention and Combating of Corrupt Activities, and the rationale to pass such resolution, conferring on me the authority to transact in terms of Section 34. Chair, the understanding that I had upon reading this was that perhaps there was a resolution that existed that gave the Group Executive of Legal Risk and Compliance authority to report in terms of Section 34 of PRECA. That's what I understood.
To your knowledge, was there such a resolution by management?
There was never such a resolution, Chair, not even by the board, because all the PRECA related matters were dealt with by the board of Popo Molefe. So the reporting was done by the board of Popo Molefe and not management, and not me specifically.
The point is that this resolution does not say anything unusual. All it does is to repeat something which every senior official in public administration, including public entities, has as a duty to report corrupt activities once they know about them.
So my understanding of the resolution, Chair?
Well, then let's have your understanding of the resolution.
What I understood, Chair, with the resolution was that the board thought that I had, been given authority to report matters in terms of Section 34. That's what I understood. And in our response, we dealt with that to the board, Chair. So I didn't understand it the way that Mr. Maleka is explaining it. My understanding was that the board of Judge Makhubele thought that perhaps there is a resolution that exists that gave me authority to report in terms of PRECA.
Well, just what was the factual situation then, as far as you know?
At the time, Chair, the factual situation is that that specific reporting was done by the Popo Molefe board. And they were dealing with all the investigations through the worksman's, instructions and what worksman's was doing. And through that, a report was compiled by the board of Popo Molefe in terms of PRECA.
Was that responded to this board of Judge Makhubele?
Yes, we did respond.
Chair, the response on that score is at page 241 from paragraph 6.3. And 6.3.1 records the following. The reports in terms of Section 34 of the Prevention of Combating of Corrupt Activities Act were prepared by worksmen's attorneys on behalf of the former Board of Control and submitted directly to the Hawks without any input from Group Legal Service or the Group Executive Legal Risk and Compliance.
Sorry, Chair, I don't have the page. I just looked at the page and I didn't find...
Page 341.
Oh, I thought you said 241.
341. Which is the response? Yeah.
Yes, Chair, I've got it there.
Do you have it?
Yes, I do have it, Chair.
You see the bottom paragraph is numbered 631.
Yes, I do, Chair.
What management was indicating there is that there were those Section 34 reports prepared by worksmen on behalf of the board and were submitted directly to the Hawks.
Yes, Chair.
And then you as management, especially your portfolio and team members, did not have any input in regard to those reports.
That's correct, Chair.
Yes. And then in paragraph 6.3.2 on page 342, management continues to say the following. To the extent that there may be a board resolution authorizing the GELRC to submit any reports in terms of Section 34, the GELRC is unaware of such resolution. GLS has assisted the investigation from the DPCI with administrative matters that relate to the investigation of Swifambo and Siangena criminal complaints, save for this administrative assistance, which entails assistance with arranging meetings with investigators, GLS and GE, LR and C have had no other involvement. Do you see that?
That's correct, Chair.
So my understanding is that at least insofar as the Section 34 PRECA reports were made by Worksmans, there were interface between your department and the Hawks, where you engaged with investigators, at least to provide them administrative support, correct?
Yes, Chair.
And you mentioned two matters there specifically, and that is Swifambo and Siangena.
Yes, Chair.
And there is no reference to the Siaya matter.
No, Chair.
Yes.
So in essence, the resolution that was made by that particular board of Judge Makhubele was not talking to what actually transpired in terms of reporting the Section 34 matters.
Yes, I think there was a bit of a misunderstanding, if I understand your
Yes.
question properly, Chair. I think there was a bit of a misunderstanding. I think my interpretation of that resolution was that the board of Judge Makhubele thought that there was a resolution
Yes.
that authorized me to report in terms of PRECA. Yes. Sorry, Chair, can I ask for some water, please?
Yes, certainly.
Chair, Judge Makhubele instructs me that there was such a resolution. We will try and direct inquiries to PRESA and see whether we can find it. And once we are able to find it, we will place it before you. If not, we will also report to you the outcome of our efforts. Indeed.
And you say your instructions are that there was,
Indeed.
and you would now attempt to find such a resolution.
Yes.
The point of the resolution is to establish what exactly?
Is to establish that when this board came into office, it required the group legal risk and compliance to provide a report in line with that resolution.
Yes. And any idea when you'll be in a position to provide such a resolution?
Chair, if it were me, I would do it immediately.
Yes.
But I act through others.
Yes.
So I'm afraid I don't want to bind them until I get to know what their timeline says. Can I
Yeah.
pay my installment to you in that regard after tea?
You may answer after tea if you like, and we will then expect you to provide such a resolution in the time that you say
Yes.
you'll be able to.
Yes.
Would
I
that
think
be
I'll
fair?
have a better clarity. I don't want to commit my attorneys.
Yes. No, I understand.
Yes.
Thank you.
Ms. Ngoye, remember one of the resolutions adopted by the interim board on 1 December in paragraph 4 related to the status of the legal panel.
Yes, Chair.
and I'm not going to go back there. What I wish to explore with you is the response of management to that part of the resolution. And the response, as I have it, begins from page 337. I'm not going to take you through each and every part of the response because my interest lies in only one paragraph of the response. But you are welcome to look at it, and if you're quite comfortable, I would like you to reflect on page 338, paragraph 625. Are you there?
Yes, I am, Chair.
And the response begins as follows. We do not support the part of the draft resolution that states that procurement of legal services should be done through the SCM department. Do you see that?
Yes, I do, Chair.
And do you confirm that that's the view which your department, responsible for legal services, risk and compliance, responded to the board that they don't agree with that resolution?
Yes, Chair, we did.
The response was manifestly that you're not going to comply with the provisions of the PFMA. That required procurement of legal services through process SCM policies.
Chair, there's a second, I'm not sure how to respond to this because of the discussions we had yesterday. I'm just looking at the third line, Chair, which states, however, if this memo does not change the views of the board in this regard, we may have to comply with it. This issue was raised before by the SCM department and the Auditor General when they were finalizing their audit. We advised them of the impracticality of this requirement, as indicated, that a more preferable way will have to have the framework used in procuring legal services being reduced to writing to ensure transparency, openness, and fairness. We have not heard anything further from the AG in this regard.
Now, if you could, for our benefit, just explain what is meant by all of this.
Yes, Chair. We'd had discussions around this particular issue. What we understood as the legal department was that every time a summons is served on PRASA, it would have to go to SCM for SCM to procure a firm of attorneys. And after the procurement of a firm of attorneys, then advise the legal department what firm of attorneys to use. What we explained at the time to the SCM department, firstly, the concern that we had was that the SCM department may not have an appreciation, Chair, of what is involved when summonses are received. It may be that also where there is an urgent application, having to go through a procurement process may put PRASA at risk in the sense that we may find that we lose time in responding to the urgency of the matter through that process. So these discussions we had with the SCM, and we tried to explain that to the AG to say, we don't understand how this is going to work, and perhaps where there is an urgent matter, and timeframes being very short, we may find ourselves in a predicament where things, procurement through, even on an emergency basis might not yield the necessary results. The other issue, Chair, that we had discussed around the specific instruction was that what we understood from a procurement perspective was the issue of price would always have to be something that is considered through the competitive process. Now, in a legal matter, the challenge would be what price do you put, to complete the matter, and what would happen when you then exceed the price that you agreed to. So we identified all those things that we saw might be problematic in terms of compliance and said, can we deal with it differently and at least allow us to provide a better solution of how to deal with this thing. In other instances, Chair, the other issue that we were concerned with is that there were matters where you would require to appoint attorneys on the basis of horses for courses, in terms of their expertise. And therefore, that too we might not be able to achieve that if we left everything to the SCM department. And I think, Chair, at the time, it was premised on the fact that we knew and understood the capabilities also of our SCM department, and also the challenges that we had had with the SCM department assisting us in putting a panel of attorneys together. So those were some of the issues that we had deliberated on and we had discussed with the AG to say, help us out in understanding how we are going to achieve this without placing PRASA on risk.
Did you get a response to your concern from the AG?
No, we didn't, Chair.
Then what did you do?
We left it at the status quo. We left the status quo as was, Chair.
Yes.
To continue as a summons comes in, because of the knowledge, we would then deal with that particular summons. That's how we dealt with it, Chair.
Ms. Ngoy, I want to be as fair as I can to the best of one's ethical duties. We have gone through the AG's report, which identified irregular expenditure arising from the use of the self-same panel. We have gone through management's response to the AG's findings. I have identified on both scores related to workmen's and the broader panel of attorneys what management promised to the AG to rectify and remedy that situation. You as management undertook to rectify the situation by March 2017. We have gone through that exercise. Management, and I put it to you, that management had almost, at best, 8 months, at worst, 9 months, to engage remedial activities to redress that issue of irregular expenditure arising from that panel. Would that be a fair proposition to put to you?
Yes, Chair.
What followed thereafter is as a result of management's failures and not the AG's problems or the board's problems. It is because management failed to live up to its undertaking and promises to the AG. Is that a fair proposition to put to you?
Is this now management referring to me as I just want clarity, Chair?
You were part of the very management which made commitments to the AG.
Yes.
Yes.
Can I respond?
Yes.
Chair, as the legal department, to remedy this particular concern, which we ourselves had, we went out on tender to invite, respective law firms to tender for participation and so on. We relied on the SCM to assist us as the end user with the process of putting a panel that would be evaluated and adjudicated upon. We did that work. We did not do it once, we did not do it twice, we did not do it thrice. It was done 4 times. And in all the 4 instances, supply chain came back and advised us that the tender either had lapsed. They decided not to proceed with it because the manner in which it was being dealt with was not understood by the people who were evaluating. So we then found ourselves, back to square one, where we don't have a panel. And we, as the legal department, could not go out on our own and finalize the procurement of the legal panel on our own. So it is not that there was no effort on the part of the legal department to do this, to rectify the issues that were raised by the AG. We did our best, and there is evidence to that fact, and I think we allude to it, Chair, in the response in this memo. So it's not that we just disregarded it. We tried. But this aspect of having to have this done was not placed with us. We relied on another area of the organization to assist us in doing it. And they failed us in every respect.
Thank you, Chair. Chair, I'd like to move on. All I wish to record is that that long explanation is now on record and it's not included in 625 or any other paragraph. But I'd like to move on. We'll leave that matter for argument. I'd like to take you back to 625. And there you expressly record, we do not support that part of the draft resolution. I must fairly suggest to you that this is a reflection of defiance by management to a resolution adopted by the board. My understanding of corporate governance relationship between management and the board is that it is a board which has the statutory powers of management and direction of PRASA, not management. Is that a fair understanding of corporate governance?
Well, Chair, I know I understand what corporate governance is, but I don't agree with the statement that Mr. Maleka is making insofar as this particular issue is concerned.
There's a line of responsibility and line of reporting between the board and management. The board is the overall manager of the business of a corporate entity. Is that correct?
That's correct, Chair.
And when it decides what should be the strategic direction of that corporate entity, management is obliged to behave in line with the wishes of the board.
I don't dispute that, Chair. This issue arose where we received that unsigned excerpt, and we had requested, to be guided accordingly. And also, Chair, based on the fact that we understood that people would impute things to the board without the board necessarily giving that specific direction, we felt it would be necessary to have a signed resolution, reflecting that this is it. And that's why we keep referring to it as a draft. Now, we never received that signed excerpt. When we didn't receive the signed excerpt, we in any event responded and provided the necessary information that was required by the board. However, insofar as this particular matter was concerned, I think one of the issues that we raised was, firstly, we didn't understand what we were supposed to do with the matters that existed. We had a couple of concerns. And what we said in our memo, Chair, was that we hope the board would engage with us so that we are on the same page as far as taking these issues forward. And that is why, in the third line of paragraph 625, we say, however, if this memo does not change the views of the BOC in this regard, we may have to comply with it. So, it's the way in which we were dealing with this matter. And there was a bit of confusion, Chair, around that draft excerpt. Because after receiving it, we were advised by Mr. Zide himself that the chairperson of the board at the time, Judge Makhubele, was not happy with the fact that resolutions of the board were released without her having finally seen how they were drafted. This is what Mr. Zide said to us. And what we found also confusing for us, Chairperson, is that when Unite Behind instituted action against PRASA in relation to this very specific issue, Mr. Zide deposed to an affidavit that said this was not the resolution of the board. So I actually don't even know, Chair, how to, and this is because we know the culture within the organization. We would have wanted, to be engaged, and not that we demanded it, but for the interest of the organization, to be engaged so that we can be aligned with the board and the board chairperson around this particular matter. There was a lot of confusion around this specific documentation.
Thank you, Chair. I'd like to move on, and I'd like to make one broad proposition to you. It was quite clear by the time you gave your response to the board on 5 December 2017 that you are aware that the board had suspended the very panel that you raised matters of impracticality or complications. And I take it that you appreciated that that panel, by virtue of the powers of the board, was suspended.
We appreciated that, Chair. We wanted guidance of what to do next. We didn't get that guidance.
I thought that yesterday, or even before, we talked about the use of the SACA panel, the panel of the South African Civil Aviation Authority.
Yes, Chair.
Yes. And that leads me to an exercise I asked you to consider, if it was comfortable to you. Because you raised something about the fact that the use of that panel would be irregular, having regard to the Treasury regulations of National Treasury, especially Regulation 16 and/or 16 capital A. You remember that?
Yes, I do, Chair.
Did you have an occasion to reflect on that proposition?
I did, Chair.
And can you please guide us? Because we have looked at Regulation 16 and 16A. What part of the regulation do you rely on for your proposition that the use of the SACA panel would be irregular?
Chair, may I be allowed to just find and unless there's a copy available, I'm happy to use that.
If it's convenient, Chair, we can place a copy of that resolution before her, or we can make copies for all concerns during tea time.
Of this Regulation 16.
All I want you to do so that we
Yes,
are
I
not
understand.
lost is to tell us, well, interrupt myself again. Treasury regulations are long. They begin from 1 to
Yes.
50. But the key ones that we are aware of, which deal with procurement, is 16 and 16 capital A.
That's correct, Chair.
Should we make copies of those only?
Just 16A.
Okay, thank you. Chair, we'll make copies of 16A. Yes.
You'll give the panel a
Indeed.
copy as well.
Indeed.
Then we might as well take the tea agenda now.
Thank you, Chair. Chair, can we ask that we should report to you that we're ready? Because I don't know the extent of the resources here. If it were in our chambers, we could give you a commitment, but somewhere here in Rosebank, resources are quite scarce.
Well, we'll await to hear from you then.
Thank you,
Mr.
Chair.
Maluleka. We will adjourn until Mr. Maluleka informs us otherwise.
Thank you, Chair.
Thank you.
Yes, Chair.
Yes.
I take it that you have had the benefit of looking at a copy of the hard copy of the resolution of 16 and 16A, which is now before you.
Yes, Chair, I've looked at Regulation 16A.
And can you guide us which part of the regulation you rely on?
Thank you for the indulgence, Chair, in getting the copy. Chair, our understanding, or my understanding, and together with that of the legal department, was making reference to the definitions, first and foremost, to what institutions would be subjected to this particular regulation. So in terms of Regulation 16A1, capital A1, which is on page 72, which is what I've marked, I hope it's right. Institution there, in terms of the definition, means a department, constitutional institution, or public entity listed in Schedule 3A and 3C of the Act. That was our starting point, Chair, in looking at the applicability of this regulation to PRASA. PRASA, Chair, is a Schedule 3B and not any of these. PRASA, that's our understanding. PRASA is not a department. PRASA is not a constitutional institution. And it's not a public entity listed under 3A and 3C. So that's how we looked at it first. Secondly, Chair, in terms of the application, 16 capital A2, it says this framework applies to all departments, constitutional institutions, public it repeats effectively. Public entities listed in Schedule 3A and 3C of the Act. So this is where we start looking at, in terms of the interpretation or our understanding of this particular regulation. We then went to, Chair, Regulation 16. I think it's 16 capital A6, 6, which is on page 73, Chair. We then said, what it says there is that the accounting officer or accounting authority may, on behalf of the department, constitutional institution, or public entity, participate in any contract arranged by means of a competitive bidding process by any other organ of state, subject to the written approval of such organ of state and the relevant contractors. Now, when we looked at that specific provision of this particular regulation, Chair, we understood that this was not applicable to PRASA because, firstly, it talks to, once again, those four entities in terms of which the framework applies. And therefore, as PRASA, as a Schedule 3B entity, we could therefore not just go to any organ of state and ask them to use their process that they would have complied with in terms of anything that we may have required. So this is in a nutshell, Chair, our understanding and our interpretation of this. And that is why we believed that the suggestion that we use the SACA panel would not be in compliance with what we are required to do, And that's why we said that instruction itself would have been irregular. And we found it difficult to then have to comply with an irregular instruction. That's where we based this, this particular, interpretation of this particular regulation.
Just to get clarity on what it is you're saying, you say that the instruction that you comply with Regulation 16 of the Treasury regulations, it couldn't have applied to the legal department of PRASA. Is that what you're saying?
It couldn't apply to PRASA
It
as an
couldn't, yeah.
entity, yes.
As an entity?
Yes, Chair.
And of course, you were part of PRASA,
That's correct, Chair.
so it couldn't apply to you.
Yes, Chair.
And you tried to clear this up with Judge Makhubele?
Yes,
Is that
we did.
correct?
That's it, Chair.
Did you ever get an opportunity to do so?
No, Chair. We didn't get an opportunity because upon writing the memo that we wrote, requesting to be engaged by Judge Makhubele, it never happened. And that is why, we were concerned that if the solution is SACA, it's an irregular solution as well. So we're trying to move away from irregularity, but we are asked to then comply with something that is also irregular, where PRASA is concerned. That was our understanding, Chair, that we had.
Yes,
And
thank
we
you.
wanted the opportunity to engage.
And as you said, you never got the opportunity to do so.
No, Chair, we didn't.
Thank you.
Ms. Goy, I mean, you know that Regulation 16A was amended by a subsequent regulation, Government Gazette number 25605 of 24 October 2003. And the amendment that was effected in that regard included the incorporation of institution in 3B to become bound by this regulation.
I'm not aware of that, Chair.
Chair, we will leave it for argument. I'm not going to pursue this, but on our argument, it will be clear that that regulation was amended in 2003 October to include PRASA. Chair, I'd like to explore the last topic, if I may, with your leave. One of the issues we asked you to do yesterday was also to look at the application for condonation which you made to the CCMA in order to refer a dispute arising between you and PRASA. And we made available to you a copy of the application. You remember that?
Yes, Chair.
Chair, it is that application which begins at volume 29, my apologies. It's a set of new documents which we placed before you yesterday.
Well, I received it this morning. It's the document you're referring to. Is it referring a dispute to the CCMA?
Indeed.
For conciliation?
Indeed.
And you want to ask the witness
Yes.
about matters arising from this document?
Indeed. Indeed.
Well, it is not really before us, but I'm going to allow you the opportunity to put your questions, but please bear in mind our mandate is to examine not the witness,
Yes.
but the conduct of the judge, particularly. If this has anything to do with the judge, we'd like to know.
Yes.
And if it hasn't got anything to do with the judge, I nevertheless would allow you to put the questions.
Thank you, Chair.
Yeah.
And you will see the relevance of it because
see.
we understand that your investigative mandates,
Yes.
including assessing every piece of information or evidence placed before you,
Yes.
in order to make findings of fact.
Yes. Well, we'll bear that in mind, so
Yes.
put the questions. Thank you.
Chair, on my pagination, the opening documentation you referred to, referring a dispute to the CCMA, is number 65. I'm not too sure on yours. Indeed, thank you. Can we confirm, first thing first, you are aware of this referral of the dispute.
Yes, Chair.
And you'll see on page 65, it has your details on it.
Yes, Chair.
Yes. I'd like to take you to page 67, if you don't mind. Under the fourth paragraph, you were asked to summarize the facts giving rise to the dispute.
Yes, Chair.
And your summary is as follows. Let's read it together so that we are at one. The applicant, which is you, has been to an occupational detriment by the respondent as a result of the protected disclosure made by the applicant to, amongst other persons, the State Capture Commission of Inquiry, and which disclosures were made by the applicant in terms of Protected Disclosures Act 26 of 2000 as amended, PDA, and which constitute a protected disclosure. I will stop there, but you're free to take up the rest of the description. Your grievance, as described, is that you were a whistleblower and you blew the whistle, amongst others, before the Zondo Commission, correct?
That's correct, Chair.
Can I take you to the affidavit which accompanied this notice of referral? Mine, Chair, begins from page 1. And I take it that this is your affidavit in support of that notice of referral, correct?
That's correct, Chair.
At page 5, paragraph 3, you indicate the purpose of that affidavit, and it is to support your notice of referral. And I ask you to consider paragraph 12.5 on page 7. You will see the preamble of paragraph 5 lists or indicates matters on which you made the protected disclosure as you see them, and that is matters on which you blew the whistle. One of them is in paragraph 12.5. It relates to Judge Makhubele. You see that?
Yes, I do, Chair.
And I see that you describe her as the erstwhile chairperson of PRASA Board and as Advocate Ntswalo Anna Makhubele SC.
Yes.
You see that?
Yes, Chair.
And I take it that you still stand by that description.
Yes. Yes, Chair.
And then to complete the picture about her, in paragraph 13.2 on page 8, you say her conduct in that regard related to irregular conduct by the PRASA chair, Ms. Makhubele. Do you see that?
Yes.
That is page
Yes,
8,
Chair.
paragraph 3.2.
Yes, Chair, I see it.
That's how you describe it.
Yes.
Yes. And in paragraph 17, page 9, you make it quite clear that those disclosures you made, including the disclosures about Judge Makhubele, they related to whistleblowing affidavit of yours and someone called Mr. Holele. Do you see that?
Yes, I do.
And you repeat the same description as whistleblowing affidavits in the following paragraphs. Page 10, paragraph 19. Do you confirm that?
Yes, Chair.
Also, page 17, paragraph 44. Do you confirm that?
Yes, Chair.
And your affidavit was signed upon the execution of the oath on 8 December 2021. Do you see that?
Yes.
On page 33.
Yes, 33. Yes, Chair.
And
What transpired at the State Capture Commission. It was then that the issues of whistleblowing came up. But in 2018, I was not a whistleblower, and the commission required one to deal with matters that would have happened before, obviously, the date of the commission. So this is where I'm perhaps not aligned with Mr. Maleka in relation to this particular matter in 2018. Even when I went to the minister to report, Chair, I didn't regard myself as a whistleblower.
Chair, we have reached the end of our questions to Ms. Ngoye, and we thank you very much for your patience.
Are you ready to re-examine? Are there any re-examination you want to put to the witness, or do you require some time? And if you do require some time, let me know how long.
Thank you, Chair. I do require some time to go through some of the issues that were raised during cross-examination. Can I have, at least because we'll be going to lunch soon, can I at least have about 15 minutes at this stage, and then we can come back, and then I will at least have the lunch hour.
Well, it's now about 12 minutes past 12. If you come back at 12:30, then you can tell me what your position is. So we will then stand down until 12:30, and then you'll inform me what you did today.
Thank you, Chair.
Yes, thank you. We will then stand down until 12:30.
Thank you, Chair.
Thank you, Chair. Ms. Ngoye, just before or after the tea adjournment yesterday, it was put to you that Judge Makhubele had not given anyone in CIA instructions to pay the amounts in the documents, or to pay the amounts as reflected in the documents. You remember you responded to that?
Yes, Chair.
Okay. And you were asked whether you disputed, and you said yes. You then went further and you indicated that it was clear that Judge Makhubele was very clear that the settlement happens. I want to refer you to volume 11A, page 33.
I'm there, Chair.
In that is an email from Tinswalo Makhubele. It's sent on Thursday, 21 December 2017. It's addressed to Mr. Madimpe Mohashwa, CC Lindikaya Zide, and subject matter arbitration for CIA/PRASA. It states, Dear Mr. Madimpe, thank you for the update. Mr. Zide, please attend to finalize the matter with respect, WRT, with respect to payment part. Do you see that email?
I see it, Chair.
What is your take on that?
It's
In line with what had been put to you yesterday, that Judge Makhubele had not indicated to anyone that there must be payments made.
It confirms my submission of yesterday, Chair, and the fact that Mr. Zide had also confirmed to me ultimately that the instruction came from the chairperson.
Thank you. This morning, you were cross-examined in regards to the issue of the panel and the suspension thereof. And it was put to you that we find that management failed to live to the AG's proposal, and furthermore, that you failed to adhere to the resolution of 1 December 2017.
That's correct, Chair.
Okay. Just a few questions around that, Ms. Ngoye. In regards to Mr. Mahashwa, the appointment of Mr. Mahashwa, was Mr. Mahashwa an external law firm who was also part of the panel?
Yes, the old panel, Chair.
But at that time, during October, November, December, at the time when Judge Makhubele was the chairperson of the interim board, was he part of the panel that was being utilized?
He was part of the panel, Chair.
And it is indicated that the resolution of 1 December 2017 was then brought about that the panel be suspended immediately. You remember this evidence?
That's correct, Chair.
Okay. Now, the evidence that we've heard is that Mr. Mahashwa was part and parcel, or was being used when the settlement agreement was entered to. Is that correct?
That's correct, Chair.
If Mr. Mahashwa was being, and you remember that the settlement agreement was in consultation with the chairperson.
That's correct, Chair.
If Mr. Mahashwa was being used and he was part and parcel of the panel members that had been suspended based on the resolution of 1 December 2017, was this resolution being properly implemented by the board then?
Well, Chair, my answer would be no, but Can I say, and this is the reason why we wanted to, discuss matters with the chair, just to get clarity on what the suspension meant and what it meant for matters that were current.
Can we just clear this up? Mr. Makhubele was part of the old panel.
That's
Let's
correct.
call it that.
Yes, that's true.
You had been given instructions, or there had been instructions by the board, that the old panel were discontinued, so to speak.
That's correct, Chair.
Yes, and that you had to go out and use other attorneys.
Yes, Chair.
It then appeared to you that Mr. Makhubele was then still being used, isn't it?
Yes, Chair.
Now, and what is it that you wanted to clear up with the chairman, Judge?
What happens to matters that are currently running? Because to simply say the panel is suspended was not giving us guidance as what it is that we do in relation to the matters that are running. So that's the conundrum that we had, to say, what to do now? Do we stop everything and then where to from there? And hence we requested to have the discussion with the chairperson, just so that we can understand some of these issues.
Thank you.
Thank you, Chair. The determination of the services of Mr. Makhubele, at whose instance was that?
I'm not understanding.
Who brought about the determination of Mr. Makhubele's legal assistance to PRASA?
In relation to this matter,
Yes.
we requested that he terminates because he was conflicted.
Were there any other matters that he was also still instructed on from PRASA?
I believe so, Chair. I'll have to check. I think so.
Okay. Now, during the cross-examination this morning, there was a lot of reference in regards to your response to the resolution of 1 December. There was a lot of response to the resolutions of 1 December 2017. You remember?
I do, Chair.
Okay. And sorry, Chair, if you could just bear with me. Sorry, Chair, I made a mark of it somewhere. Okay. Going back to the issue where it was indicated that you failed to live to the AG proposals, you then gave a response. You remember that?
That's correct, Chair.
Okay. And your response in regards to that being put to you is that the legal department, you had, as the legal department, you wanted to remedy the concern. You then gave a long explanation, and you went on to tender, inviting law firms, and the issue that you relied on the SCM to assist to put up a panel. You remember that response?
Yes, I do, Chair.
Okay. It was then put to you that that response that you had given was not included in the document at paragraph 6.2.5, meaning the document as contained in volume, that response which is in volume 16.4, pages 328 to 342. It is volume 16.4, page 328 to 342.
Uh, 328. Yes, I'm there, Chair.
Okay. It was put to you this morning that that response with regards to how you tried to remedy the situation in in using the SCM processes, that response was not included in that document, and you were then referred to paragraph 6.2.5. You remember that?
I do recall.
Okay. I want you to have a look at this document, your report, to, or in response to the resolution of 1 December 2017.
I've got it, Chair.
Okay. Let us go to page 336.
I'm there, Chair.
Paragraph 6 in its entirety. When I say paragraph 6 in its entirety, I'm referring to paragraph 6.1.1, paragraph 6.1.2, and as follows.
Yes,
Do
Chair.
you deal with the issue of the supply chain management processes that you had embarked on?
Yes, yes, we do, Chair.
So it was incorrect when it said you did not address same in that memo.
Yes, yes, Chair.
And in paragraph 6.2.11, you have
I'm there, Chair.
it is clear from paragraph 6.2.11 that you have always indicated that there was a need to procure a new panel.
Yes, Chair.
And in paragraph, just under that paragraph, you then deal with the risks of not having a panel of service providers that service PRASA on a daily basis.
Yes, Chair.
And again, this speaks to the issues that you dealt with regards to the risks associated of not having law firms to deal with the urgent applications or the existing litigation at that time at PRASA.
Yes, Chair.
Your correspondence or your memo on page 342, in the last paragraph, again, you in that paragraph indicate the last sentence. This memo is intended to be an engagement on the best interests of PRASA in the delivering of the mandate of GLS.
That's correct, Chair.
Now, this memo is dated. This memo, as we've already indicated, was on the 5th of December 2017.
That's correct, Chair.
Yesterday, you were referred to a meeting that took place, or a request for a meeting on 8 February 2018. You remember that?
Yes, Chair.
Okay. This meeting just get me that email quickly, Barry. Right. Volume 8, page 287.
I've got it, Chair.
Between the 5th of December 2017, that memo that you sent to the chairperson, and 8 February 2018, had there been any invitation to discuss this issue of CIA with the chairperson?
No, Chair.
This meeting of 8 February 2018, were you aware whether or not the chairperson was going to be present?
Well, it was clear that it was not addressed. She was not party to the invitees, Chair.
And this meeting of 8 February 2018, it's called on the 8th of February to a meeting. Yesterday, you were also referred to the documents indicating that there had been the arbitration awards that had taken place on the 7th of February 2018. Is that correct?
Just remind me, 7th,
7 February, you were referred to those documents, the awards that Judge Brandt had given.
yes, yes. Yeah.
So the meeting was the next day after the awards had been provided, or had been given
Yes,
by
Chair,
courts?
yes, yes.
Okay. Let's go on to page 289. This is the correspondence by Mr. Kramet Molepe to yourself with regards to a proposed meeting with the chairperson of board to discuss the CIR matters.
Yes, Chair.
Okay. This correspondence is dated the 8th of March 2018.
Yes, Chair.
And you testified to indicate that on the 9th of March 2018, the matters were going to be in court.
Yes, Chair.
Okay. Prior to this invite, which is officially on an official letterhead to yourself, had there been any invite to yourself by the chairperson with regards to discussing the CIR matter?
No, Chair.
Okay. Had there been, and if you look at paragraph 3 of that correspondence, which is on page 289, it says the chairperson has indicated that she was willing to have a meeting to ensure that all of us act in the best interest of PRASA. The question is, prior to this correspondence of 8 March 2018, had there been any indication that the chairperson wished to include the legal department so as to ensure that the best interests of PRASA are reserved?
No, Chair.
Chair, at this stage, I just want to go through that issue. I'm going to ask that we start the lunch adjournment a little bit early so that I can go through the other issues, especially in regards to the documents that we were provided with this morning.
Well, we'll break and we will resume, hopefully, when you're ready around 2 o'clock or so.
Thank you, Chair.
So, you'll have to come back at 2 o'clock. You understand?
Yes, I do, Chair.
Yes. Thank you. We will then adjourn for lunch, I suppose, today. Thank you.
Thank you, Chair.
We'll resume again, just to remind you, you're still under oath.
Yes, Chair.
Yes.
And do you have it?
I have it, Chair.
It says, take further notice that the existence, nature, terms, and conditions of this offer are strictly confidential and shall not be disclosed by either party in any manner or form, directly or indirectly, to any person or entity under any circumstances. Do you see that?
I do see,
Yeah.
Chair.
Take you to the next document on page 283. It's also headed settlement offer.
I see it, Chair.
You were also brought to the attention of this document. And I wanted to take you to page 284 of that document.
I'm there, Chair.
284.
Yes, I'm there, Chair.
The last paragraph, take further notice that the existence, nature, terms, and conditions of this agreement are strictly confidential and shall not be disclosed by either party in any manner or form, directly or indirectly, to any person or entity under any circumstances.
I see it, Chair.
What is
Yes.
sorry, you see it?
Yes, I do.
What is your understanding of these clauses as we see them noted in the settlement office?
That no one else can know about these settlements that has been entered into, except obviously the parties that are part of these settlements.
When did you see those documents for the first time?
These documents, Chair, I saw them during the March period, as I'd indicated.
When you say March period, you mean March
March 2018,
18?
Chair.
Thank you, Chair. That brings me to the end of my re-examination on the cross-examination, but at this stage, Chairperson, there is a document that was going to be sourced, I believe, from PRASA, and so I'll reserve my rights, but I'm sure that we will be able to continue with the other witnesses.
We'll deal with it if and when it arises.
If and when it arises, Chairperson.
Yes. Judge Mshidi, do you have any questions?
Oh, yes, Chair. Just very briefly, Ms. Ngoye. I am going to ask you a few questions, not necessarily in sequence, but just to clear up certain issues. The evidence before us is that you were at PRASA from 2011, is that correct?
That's correct, Chair.
So from the time when Judge Makhubele came in October of 2017, you had been there for some time before her.
That's correct, Chair.
I assume that you had the knowledge of the culture, the workings at PRASA more than what she had when she came there.
That's correct, Chair.
And then the next issue, of course, is you made an application to the High Court in Pretoria for the rescission of a judgment, default judgment. Do you recall that?
Yes, Chair.
And that rescission was granted.
That's correct, Chair.
What happened thereafter? What did CIA do after you obtained the rescission?
They didn't follow up with the litigation, Chair.
They didn't follow up at all,
No.
up to now.
What I know, Chair, is that they went to rather to the Department of Transport to request the minister to intervene so that they can be paid.
And then there is a document I saw now. Following the board meeting in October 2017. You have that minute with you there?
Which one, Chair?
It would be it's headed minutes of the meeting of the board held on Monday, 30th of October 2017. I note that you were not part of the meeting.
Chair, can I be referred to the document? I can't remember which one specifically that one is.
What is the minutes of the meeting, the first meeting of the board, of the interim board?
Okay, Chair.
But what interests me is what is contained just can't lay my hands on it now myself as well. But I think it deals with the delegation of authority somewhere. In any event, your evidence is that when Judge Maluleka arrived at Prasa, the new board or her board did not have their own delegation of authority.
They had
never
not
reviewed
Sorry, Chair.
it. That's according to the minute, is it? And understood you to mean that they simply carried on the basis of the previous board's delegation of authority.
That's correct, Chair.
They never had their own.
I guess they were working towards getting their own, but in the interim, they relied on the previous board's signed delegations of authority, Chair.
Yes, and the minute also indicates that somebody was going to look at reviewing the delegation of authority.
That's correct, Chair. I remember that.
Did it ever happen?
No, not to my knowledge, Chair.
So how were they functioning then, without their own delegation of authority? What was your understanding?
Was that the previous board's delegations of authority would continue up until such time that if there was anything they wanted to change, they would do so, and they had the prerogative to do so, Chair. So PRASA did not exist without the delegations of authority. It's just that the board of Judge Makhubele had not gotten around to finalizing their own, which she would have signed off as the chairperson of the board.
And what was your understanding? You testified about interim boards, the one before Judge Makhubele arrived and the one of Judge Makhubele as interim boards. What was your understanding of an interim board? What was the lifespan of an interim board in your experience from 2011 up to 2017? Or?
At any given time, it could be disposed of, Chair. It was not. At any given time, effectively, it could be changed. We could have new board members. It was not a permanent board. That was my understanding. It just didn't make sense, Chair, to one, because also it was not catered for in the legislation. So interim meaning in the interim, whilst perhaps maybe the minister's trying to finalize a full board.
But we also heard that this particular board of Judge Makhubele did not form a quorum
Yes, Chair.
all the time,
Until
from their first meeting in October 2017,
I think
even including the meeting of the 1st of December.
I
It was
need to.
never quorate, eh?
Yes, Chair. I need to recall when I think at the time of the meeting of the 1st of December, they were still not correct, and that is why they dealt in the minute. If I recall from what I saw the last time, they dealt with the correction of the board in their own meeting.
Would it be fair to suggest that all the resolutions they took were not valid?
Well, effectively, yes.
Because they're not correct.
Yes, Chair.
Interim board.
Yes, Chair. The risk that arose is that they could be challenged. If anybody did not also agree with those decisions, they could be challenged, and they were not correct and set aside.
Chair.
Can I just
Thank you
come
for
in here?
now, Mr.
Sorry, just before. Between December 2017
Yes, Chair.
and March 2018, was the interim board, to your knowledge, ever properly constituted?
No, Chair.
What happened to the decisions that were taken then?
I guess there was no one came through to challenge them, Chair. They were there. They stayed. They remained.
And just one question before I refer back to Judge Mshidi. At some stage, you asked for a signed resolution or part of a resolution that was signed.
Yes, Chair.
Yes. Did you ever get it?
No, Chair. I never did.
And did you try to find out, or did you find out, whether that resolution had been properly taken?
Yeah, we did, Chair. We did, and that is why, the whole issue just baffled us when we then read Lindikaya Zide's affidavit, where in that affidavit he says it was not the resolution of the board. So we were very confused as to what it is that we are dealing with, and also the fact that the chairperson had taken issue with the draft excerpt having been released to us without her having seen the final draft thereof. So, we never got to receive the final and signed excerpt.
If the chairperson didn't release the unsigned part of the minute of that meeting, then who did?
Chair, and she was a committee secretary. It was a committee secretary by the name of Martha Kotu who released that particular excerpt.
Yes, thank you, Judge Mshidi. Do you have any further questions?
I must ask you this as well. The evidence suggests that at some stage, I think towards the end, attorneys Diale Mohashwa filed a notice of withdrawal as attorneys of record on behalf of PRASA, is it right?
That's correct, Chair.
Who gave the instructions to Diale Mohashwa to withdraw?
It was Mr.
Did they
Dingis.
do it on their own? Did
No.
somebody tell them to file?
It was Mr. Dingiswayo and I.
Sorry?
Chair. It was Mr. Dingiswayo and I, who requested Mr. Diale Makhashwa that he would have to withdraw as attorneys of record because if we felt he was conflicted. And we relayed that we agreed with Mr. Kramet Malepo, who was the acting group CEO at the time.
Oh, thanks.
If you, thank you. If you could just explain, what was the conflict?
The conflict was that Mr. Diale Makhashwa had been part of the settlement agreement that was concluded. And our understanding was that the settlement agreement was going to be made an order of court. And when he received the notice of motion, he didn't know how to then deal with the notice of motion and challenge the office being made an order of court. And we wanted to have that particular notice of motion opposed. So it didn't make sense that he would also oppose it, sorry, Chair, when he was part and parcel of that settlement that was entered into. So we relieved him of that conundrum that he found himself in, and he agreed and he was relieved, Chair, to do that.
Thank you. Yes, Ms. Selebu.
As at the 1st of December 2017, when the resolution was taken to terminate the panel that was in existence,
Yes.
was Diale Makhashwa part of the newly now constituted panel?
I don't know. I cannot say. We had not been. I didn't even see the list of the SACA panel, Chair.
At the same time, was there a directive in relation to the matters that were already in the hands of the panelist that was being terminated?
If there was a directive, sorry, Chair, I'm not with you.
I would assume that the panelists did not have one matter, or Diale Makhashwa was not the only law firm that was doing work for PRASA.
That's correct.
There must have been others
That's correct.
that were in the panel that was being terminated.
That's correct.
What happened to those matters?
Well, that's the challenge that we had, because we then didn't know what do we do with those matters, because we couldn't just abandon the matters that existed. So effectively, those panels that had matters running, continued with running those matters.
Okay. All right, thank you.
Thank you.
Well, let's just deal with Judge Makhubele's interaction with you personally.
Yes, Chair.
When did you first get to know that Judge Makhubele was appointed as the chairman of the interim board of PRASA?
In October, Chair, when she was appointed, that's when we got to know.
When did you get to know that she had been recommended by the JSC for a judge?
She communicated it, I guess maybe one did not think, but I remember in November when I met with her, she kind of like mentioned it to me.
She mentioned it to
Yes.
you, and so you got to know at the time she mentioned that, which
Yes.
you say would have been in November.
In November, Chair, yes.
And if you can, answer the question. If you can't, you just say that you
Yes,
can't.
Chair.
What did you expect her to do as far as the board was concerned?
I didn't even think about it, Chair. I didn't even think about it because the term had not commenced, so I guess I didn't think about it. of her, going to the bench. So I didn't think about it.
Now, we know that there was a board meeting on the 1st of December.
Yes, Chair.
You did not attend that meeting.
No, Chair, I was not invited.
Why not?
I was not invited to that board meeting, Chair.
Were you ever invited to a board meeting chaired by Judge Makhubele?
No, not that I can recall, Chair. No.
Now, when did you first get to know about the litigation between PRASA and CIA?
In 2015, Chair.
It started.
Yes, Chair.
The issue that we are concerned with appears to have arisen around December 2017. Would that be correct?
But November
November.
2017, Chair.
Yeah. And the litigation department, what was their involvement, you being the head of the litigation department, with the litigation that CIA had brought in 2015?
The litigation department was defending the matter, Chair, having briefed Diala Makhashwa.
Now, at some stage, CIA went into liquidation.
That's correct, Chair.
When was that?
That was 2015, 2016. I stand to be corrected, Chair. But it was during the process of the liquidation, of the litigation.
By December 2017, were they in liquidation as far as you knew?
They were already in, yes, they had already applied to be placed in liquidation, yes. They were in liquidation, sorry.
Yeah.
If I understand you well, Chair, the process was underway.
When do you know when they went into liquidation? When were liquidators appointed for them?
They advised, I think, round about 2016, I think, Chair, it was. So I might get it wrong because I was not close to the matters, Chair, but it was around 417 took place, I think, early 2017. So I think, obviously, before then, they would have indicated that they're placing themselves in liquidation, Chair.
And the litigation, which ended up, when you set it aside in March, or when I say you, I mean PRASA set it aside in March 2018.
Yes.
In whose name was it brought?
In CIS, in their own CI, not in the liquidator's name.
Why was that?
Chair, those were the questions we had, because if it was understanding how the liquidation process works, it ought to have been the liquidator or the lawyers of the liquidator. It was in CIA's name that the matters were still running. There's no reference to the liquidator in terms of the court process that was ever, involved. So it was just the companies themselves.
No, what I'm interested in is assuming PRASA paid.
Yeah.
Where would the money have gone to?
It went into the Matopa attorneys.
Yes.
Yes. Well, the sheriff attached, Chair, and the instructions came from Matopa, it's Matopa
Yeah.
attorneys, Chair, to have the execution done on the day of the judgment.
But the company was in liquidation.
Yes, Chair.
And do you know whether the company in liquidation ever had anything to do with this litigation?
Well, it was one of the same, you mean the liquidator?
Yes, the liquidator.
I don't know, Chair. I don't know. I don't know, because my understanding is that the liquidator would take over.
Yes.
And those were some of the things that we asked to say, why is Matopa running with this thing if this thing is in liquidation?
And you say, after having set aside the default judgment, that was in 2018
Yes.
to now.
Yes.
That is 2023,
Yes, Chair.
as far as you know.
Yes.
And I'm only concerned with your knowledge.
That's it, Chair.
The matter has come to a standstill, so
Yes, Chair. They didn't even reply to our papers in relation to the rescission. They left it.
Now, let's just deal with your dealing with Judge Makhubele. You say she was appointed around October, we know, 2017.
That's correct, Chair.
In November, you had a discussion with her.
Yes, Chair.
Did you have any other discussions with her after November 2017?
No, Chair. No, I don't recall, Chair.
Yeah. Thank you.
Sorry, just to follow up again. Where do we get a copy of the court order liquidating CIA? Are you able to access that document?
I can try and ask, Chair.
Sorry?
I'll ask, Chair, I don't know, actually, I don't know.
Chair suggests that the document be handed up to the evidence leader and for all of us to.
If you could.
I can find out, Chair, I can ask the.
Thank you.
Thank you.
No further questions, Chair.
Mr. Maleka, is there really? Yeah. Well, remember, this is not cross-examination. You may just.
No, I know
yeah,
that, Chair.
Yes, yes,
And
thank
by
you.
this stage,
Yeah.
I know by this stage. Ms. Goya, can I ask you to reflect on the last set of questions which the Chair raised with you about liquidation and representation of the DB in liquidation at various litigation fora involving it and PRASA. I have before me the affidavit which was made by Advocate Buotes SC, who by now should be common ground. He represented CIA. You accept that he represented CIA?
Yes, Chair.
Yes. Now, if you turn to volume 19,
Yeah, I got it. I've got it, Chair.
can you go to, just for contextual purposes, page 45?
I'm there, Chair.
This is the response by Advocate Buotes to the complaint that Judge Makhubele lodged against him with the Pretoria Society of Advocates. We've dealt with it before. Can you go to page 46 at paragraph 6?
I'm there, Chair.
Advocate Buotes said the following, Mr. Johann Krause, hereinafter referred to as Mr. Krause, is the managing member of Krause Inc. Can I stop there? Does the name ring a bell for you?
I don't know, Mr. Krause.
Messrs. Matopo and Krause represented the duly appointed liquidators of CIA DB Consulting Pty Ltd in liquidation, hereinafter referred to as the company. Do you see that?
I see that, Chair.
So according to Advocate Buotes, this company in liquidation was represented by these two sets of attorneys upon the instructions of the liquidators. And I take it you have no reason to doubt it.
I can't, Chair.
Yes. If you go to page 47, paragraph 7,
I'm there, Chair.
I, that is Advocate Botas SC, received instructions from Mrs. Matopo and Krause to represent Sierra DB in litigation that was initiated in the Higher Court of South Africa, Pretoria, and he gives the now familiar case numbers that we have dealt with. Do you see that?
I do see it.
And so he was not representing the company only. He was representing the liquidators of that company. And I take it that you have no reason to doubt what he said.
Well, I don't, Chair.
Yes, thank you, Chair.
Well, I don't think there's any other further business. You may be required to come back and clear up matters that arises if there are any further with this. But for now, you are excused.
Thank you very much, Chair.
And thank you for coming.
Thank you, Chair. It's a pleasure.